Honorable Minister, Honorable Judges of the Supreme Court, organizers, eminent people on and off the dais, ladies and gentlemen. Mr. Prabhakaran, while delivering his speech, mentioned that Justice Shalmeshwar has the distinction of having a strike-free tenure in Kerala. On the annual of my completion of 1 year in this court, I must confess my failure on this account. But then there is always hope for the future. The most crucial issue, I think, which the Bar Council has to tackle today, in my view, is that the crucible is the legal education which we have. Therefore, what the law schools are imparting today and what is the quality of legal education is a very important factor in seeing how much assistance the court get from the lawyers. We have, I'm told, almost 1,000 law schools. How many of them are giving quality education is a matter of concern. Of course, there are aspirations of the people, so you need to have enough education institutions for that purpose. But I do believe that periodic review of legal education institutions, which I am told is now being carried out, is a necessity. You have examples of other technical education institutes where there is a periodic review to determine whether the parameters are being met or not. The second stage comes when these people pass out of the law schools and the enrollment has to take place. Well, Mr. Mishra, the chairman of the Bar Council, took words out of my mouth when I said that it is necessary to find out how many people are really involved with the practice which is going on in courts. How many of them are genuine? How many rely for the bread and butter on the profession? How many people are in different fields? Because we've had various experiences as judges where I found, say, even in a raid on infringement action in a trademark suit, there's a big board of a lawyer fixed there. And ultimately it was found that he registered himself sometime, went into business, had been in the business for about a decade, but found it convenient to put the board there so that there is no apparent action which may be taken for his violation of the law. This system must, in my mind, cease, because the legal fraternity is actually called a noble profession because it is assisting the court and assisting the litigant in getting delivery of justice. Therefore, their conduct comes into more picture. There are people who will help in laying down the law. I think a large extent the problem can be solved if we can segregate who are the actual practitioners and how they can be also empowered and dealt with their difficulties. One of the appeals that's made was to the Honorable Minister that the assistance to the Bar Council should be upped so that they are able to provide facilities both for training of lawyers as also for unfortunate occurrences. I'm sure the Honorable Minister would look into this because both empowerment of the bench and the legal system has in turn dependent on the empowerment of the lawyers. I do believe a lot of youngsters who come into the profession initially feel a sense of frustration that arises because there is a long gestation period which is required before one can establish yourself in the profession. People do tend to take shortcuts, and that is a compromising aspect, and then it becomes very difficult when you get used to making easy money out of the profession. So control of discipline is another area which the Bar Council would have to expand and see. And where there is felt that there is a violation of the norms of the Bar Council, there should be a quick remedy to it, a quick decision, so that people learn that they cannot get away with it. One of the great areas of friction, I think, between the bar and a cause for strike is the friction in the police and the bar. This is intrinsic in its nature because there are a lot of interaction between the two, especially on the criminal side. What can be done about it? Different courts have tried to set up mechanisms to solve this problem out. If we can have, I think, a look at a concept of a redressal mechanism or an institutionalized mechanism all over the country, where if there is a problem, that can be addressed rather than resorting to abstention from court, it would go a long way in assisting the court. This is an aspect which can be looked into. I also believe that both the bar and the bench each have to accept their own responsibility because we have been created for the public. We have not been created for ourselves. The infrastructure which we create, the benefits which we get, whether for the lawyers or for the judges, is with the object of ensuring justice to the people. And the people are not willing to stand for years together to await their justice. Therefore, the worrying aspect is that despite increase in population, we have a decline in civil jurisdiction and a tendency to go on the criminal side. The reason is that the criminal jurisprudence is being resorted to settle civil disputes. This is again an aspect which has to be seen how we are able to address this problem. I have been appealing to the bar in Tamil Nadu or wherever I have gone that for a professional, the mode of protest should never be a strike. The Honorable Supreme Court has already observed in it, I need not repeat. There are better methods of expressing your dissent. You are the people who express that dissent for the litigants. You represent the litigants in court. You are the agency to represent them before the court. If you stop working or selectively work, what is going to happen to the litigant there? His time period will go ahead by another couple of years. There is I'm told, a novel way of protest in Japan which is used by even factory workers, where they don't stop work. They say, we will work, they work sometimes with a black man, or they will work, more importantly, say that we will work extra 15 minutes or half an hour. If you have something to protest, may I appeal to you, instead of abstaining from work, say we will work 15 days more. And I assure you, the judges will cooperate in working that extra time. If we are able to achieve and give faith to the people by accepting that our working and our quicker delivery system is something which is to be looked upon, these negative isms which we think about at times, there's going to take 100 years for litigation to get over, will go down, because a case does not become appendicy, really, if I may say so, on the day it is filed. Every case has the time to mature, but cases which get old are a matter of concern. It is time we use technology, it is time we use management systems, it is time we rope in professionals and experts from outside to look after our systems, so that the judges are able to concentrate on judicial work and the lawyer is able to concentrate on arguing in court, and the other issues are handled by professional agencies to deal with the situation. I end with the same appeal. Please work for 15 days more. Thank you. Eminent people on and off the dais. I just told Justice Gopal Gowda that I don't envy the person who has to speak after you, not knowing that the people managing here have made sure that I face the music. After such a fiery speech, there is no point in trying to create a parallel. See, I was looking, we have merged 2 sessions into one. So I was only endeavoring while I was sitting here to think what could be said, which would touch upon all the 3 issues and how to link the 3 together in some cogency. I was actually supposed to speak on the issue of environment, which was the 2nd chapter. So I'll try to start from there and see how I can link it in a short period of time, because I know you have already had a long day. See, if we look from the basic fundamental issue of environment, there is undoubtedly a conflict between the environment and man. If we look at other species, most of them don't come in conflict with nature. The animal lives there, the sea life goes on in the sea. It's not that the bigger fish doesn't eat the smaller fish, but it does out of need and doesn't do it out of greed. So if you look from the perspective of the environmental conflict, the basic thing is that we have encroached upon areas which are preserves of others, whether we are losing species of animals, whether we are losing species of life in the sea, where you're talking about certain species dying out. They exist, so there is an importance in the ecological sense. And we also owe it to our next generation, as our previous generations have given us this earth, to see that we manage in a way where we leave resources for the generations to come. It is too early to say. We are already talking about there being another planet where possibly the similar to requirements of Earth are there. But it's a long way forward before we can say that we are going to ship so many people out there. Yesterday I was watching the TV when they said that the kind of food we will have to generate, for example, by 2050, is a huge percentage ahead of what we are doing now. And the other hand, they tried to compare that the developed part of the world wastes millions of tons of food every day where food is thrown away. So what is happening is somewhere there is so much excess and there is so much of deficient that we are not able to transfer that surplus into the deficit areas. That's the reason in India, I'm sure, all of us have been taught from day one, at least our generation, that don't waste food. Because we've seen the paucity of the food. We've seen days when the PL480 rice used to come. We've seen where sugar was rationed, where rice was rationed. So there's a little more consciousness. But if you see the developed part of the world, some of them would think nothing of throwing food, because they would say, why serve a second time? So the helpings which would be served would be much more. Therefore, there has to be a change in this and a change in sensibilities. Each area has this peculiar problem on environment issue. Madras is located near the sea areas. We've had issues, for example, the turtles coming here and their loss of life. Compared that with the requirement of the fishermen to fish and look to their livelihood. These are all innately problematic area, but everything is found into a solution. For example, they would say, well, if the boats are engaged and have an escape route through the nets, it is possible that this damage to wildlife doesn't take place. Therefore, the critical thing is how to find that balance between development on one hand and ecology on the other hand. As was being said, we set up the specialized tribunal for this purpose. The litigation also comes to court. And these conflicts are increasing on account of two reasons. One is a genuine conflict which takes place, and endeavor to resolve it, where activists on the environment side come to court to represent. The other, it is equally true, and we must accede to it, is also motivated litigations which are taking place. Because you don't want a particular development to take place, often supported by forces who would like to set up the same thing but compete with it. Similarly, sometimes there are the international ramifications where there may be people from other places who would not like that particular development to take place. And therefore, specialized knowledge becomes important, because at times the court may not have the complete depth of knowledge to look into the various issues of environment and distinguish between cases which are arising from competitors or which are really concerned with the problem at hand. When we talk about this issue of environmental law, in a way, what is the similarity, I thought, with if you look to the issue of a public litigation policy? Well, the first and fundamental thing, I think, is again resolving of a conflict. As in environmental issues, we are endeavoring to resolve conflict between a man and nature conflict and the requirement of certain people as against the industrialization process. We have a court system where I don't think anywhere in the world there would be so much litigation between citizens on one hand and the courts, the government on the other hand. The Honorable Minister mentioned about litigation policy, but the fact is 70% litigation is generated between the citizen and the government systems. So somewhere that internal redressal mechanism is necessary. We even have a situation, as was said, a public sector would fight another public sector, one government arm would fight another government arm. One part of the department will say, well, I have to reconcile this with another government department. And we keep asking questions as to how are we supposed to settle intergovernmental department disputes. Any litigation policy must ensure that fruitless litigation doesn't go on. We are today faced with a situation that the approach is, oh, get it done from the court. Then I am secure. Then an order has been passed to get it. So you literally force people to go to court to get a certificate. Or the government will say, let us take it in appeal, let them dismiss it, then we'll implement it. So the approach is what? Get a certificate of dismissal from the court. So many litigations come up where if really the lawyers ask, the fact is there is, say, no merit in the appeal of the government authorities. But the battle will be fought right till the Supreme Court, because there is no accountability as to which matter should be taken up. Nobody wants to take a decision in the system as to what is right, other than get a certificate from the court. This is one area, if it is tackled, I think, the burden of the courts will decrease considerably. Is it not surprising that there are 30% private litigation only? So if out of these 70% litigation of citizens versus government, even half of it is knocked off, and we are left with, say, 60% of the current litigation, the areas would not be a problem. We have to look to criminal side litigation from point of view of the state where people have, what is the solution where a person has, say, served in non-heinous crimes half the sentence? Some broader policy will be taken, once and for all would have to be taken, to see that we get a chance to make a new beginning. Otherwise, we'll keep getting bogged down by the litigation already which is there. It is not that we are not capable, the bar and the bench, of tackling the current weight of litigation. The problem is the accumulation of areas which has taken place over a period of time, where some innovation would be required to deal with this problem of pending litigation. And a major issue can be if the government is able to have lawyers in whom they have faith, and then adhere to the advice of those lawyers, so that you are able to knock out unnecessary appeals and cases and take the courage to take the decisions instead of leaving everything to the court. Another concern with this is, though they have been saying that we create new legislations. When we create new legislations, any developed system of litigation would ensure that you will first find out what is the impact of that litigation. Your legislation, how much litigation is going to create. One classic example was the Negotiable Instrument Act, 138. When it was brought in, nobody studied as to what would be the quantum of litigation generated out of it. So much infrastructure is required, so much manpower is required, so many judges are required for it. That legislative impact study is something which is extremely important. And coupled with that, I think, and the Bar Council must encourage interaction with the government, I think, is the issue of legislative drafting. It's a specialized skill, legislative drafting. And a lot of litigation is arising from the manner in which sometimes legislations are framed, which shows that there is some lack in expertise in doing so. What is happening, at least to the extent I found out, was that each government department has somebody who is familiar with it, and it's given to him to draft. While if you see some of the older legislations, they've withstood the time, other than the process of reformation of society in which they change. But there's no quibble over understanding the words of a section or a rule. Today we quibble over that understanding, which is also creating its own problem. Coming to another linked issue with this, access to justice also envisages creating an environment in which the litigant approaches the court not overawed by the system, but as a helping system. Our court systems, if you ask an average citizen, and you must be doing as a lawyer and a judge, he is very skeptical, he is overawed, he thinks this is something which has been created to, I am forced to go here, but how will I handle it? There has to be an ease of litigation which is necessary. And that may require use of technology, which I do believe can facilitate if the litigant to man contact in the courts and the registry is reduced, and he at home can find out what case is cleared, when is it going to be listed, how will it be managed. Issues have been mentioned about adjournments being taken, ADR being used, but we have to devise a more professionalized system. For example, one issue is of fixing times for hearing. There are certain courts which have said, okay, functioning in other developed countries, that there are time-slotted cases. So you realize that these 5, 7, 8, 10 cases are going to say 2 hours. So 10 to 12 these cases will be taken up. Now in that process, if it spills over, it doesn't taken up, another date is given, so that the next slot doesn't get removed. We have a lot of wastage in our system of time. I have been a lawyer and I realize you keep waiting, not knowing whether the case will reach or not for the whole day. Or you know that it's not going to reach for the day, but if the list collapses and it reaches, then your case is likely to be dismissed. So if we improve the management system, valuing the time of the judge and valuing the time of the lawyer both, I think we will be able to serve the system much better. In an overall perspective, let me say what Mr. Mishra said today. If he can implement, I would say, even 50% of what his belief is, because I must identify that a large part of it I believe in it, I think we will have a better and more efficient system to serve us. The greater concern, if we address the problems of the lawyers, is, as he said, are all lawyers genuinely qualified or not, firstly? Have they done their job in taking the exams? What is the quality of lawyers we are producing? Are they getting guidance from their seniors to improve their system? Make examples of people who are first-generation lawyers and have risen, and there are a lot of examples, good examples of them. and advise that it is not necessary to take a shortcut for success. Lawyer's success cannot be kata panchayats. The lawyer's success is one who argues in court and addresses. I used to at times advise some not here in other courts in Delhi, in Punjab, lawyers, the younger lawyers had a get together and I agreed to come and interact with them. I said, you ask whatever question you want to ask. You want to ask an unpleasant question to me, you are free to ask. The apprehension is that no, you see, if the senior appears, he will get relief. If so-and-so appears before so-and-so court, he will get relief. I'm not saying aberrations are not there. It would be foolish for me to think so. But also I told them, look, if you are sitting and instead of sitting in the coffee house and criticizing judges and senior lawyers that something must be going hanky-panky, that is why they are getting relief. Why don't you go to court and sit there and watch that lawyer arguing? Is there something he does differently from which you can guidance, which will show and improve your expertise? We were advised as youngsters, if you don't have work, earlier in the beginning you don't have very much of work when you start doing yourself. If you are free, go and sit there. So-and-so is arguing. Say a Falin Aravind is arguing, or Sori Sorabji is arguing there, or an eminent person here, a senior counsel is arguing. If you watch and see him, I think there is a lot to be learned even from on-spot study of somebody who is arguing well. How to present a case. How to be able to present the case without fighting with the judge. Because the fundamental is that the judge holds the pen, so you have to persuade him. You may shout all you like, but unless you are able to persuade him to your point of view, his pen will not weigh in your favor. So I can only give one example. One gentleman in court tried to raise his voice. So I only told him this. I said, look, I have been arguing counsel. I can raise my voice also equally well. But please remember, the pen is in my hand, so I don't need to raise my voice. That's the hard fact. The success stories in the legal profession, there are a large number of them, which are because they worked to it and understood how the system works. Don't look to the exceptions who deviated from the system and have not been able to, and have still been able to succeed. That you will find in every field. But look to the examples which you need to study and see how that works. And I think the feeling of some element of frustration which the younger lawyers have, which all of us have had at the relevant stage of time, can be reduced and constructively used by adopting such a strategy rather than only going around the corridors of the High Court shouting slogans. I can't complain today. I've received a lot of support from this side at least, advising all of you what should be done. I still pray and hope that I'm able to establish that system and have that interaction with you, where both of us can work together for improving the system, delivering justice to the common man, for which both of us exist. Thank you very much.